If you just opened an envelope and found a summons and a petition inside, take a breath. Getting served with divorce papers is disorienting even when it isn't a surprise, but there's a small, specific set of things worth doing first, in a specific order, before you react to any of it. A California divorce case generally starts with two documents served together. The petition, Form FL-100, states what your spouse is actually asking the court to order. The summons, Form FL-110, puts you on formal notice of the case and states your deadline to respond. Read both, calmly, before deciding on next steps. The clock that matters here is fixed no matter how quickly you react emotionally, so there's real upside to reading carefully first, and no upside to rushing. The summons does two jobs. It tells you formally that a case exists, and its back page lists what are commonly called the ATROs, the automatic temporary restraining orders. This is the part people misunderstand most often. The ATROs aren't something your spouse is imposing on you personally. They took effect on your spouse automatically the moment they filed the petition, and they take effect on you automatically the moment you're served. From that point forward, while the case is open, and unless you both agree in writing or a court orders otherwise, neither of you can remove minor children of the marriage from California without the other's consent or a court order. Neither of you can cash, borrow against, cancel, transfer, or change the beneficiary of an insurance policy, life, health, auto, or disability, without consent. Neither of you can transfer or dispose of property outside the ordinary course of business without written consent. And neither of you can change beneficiaries on retirement or insurance accounts in a way that affects the other spouse without their agreement. Ordinary bills and everyday spending are still completely fine. What the ATROs stop is major, one-sided moves while the case is open. Once you've read the summons, read the petition section by section, not just skim it. It states whether your spouse is requesting dissolution, legal separation, or nullity, what they believe the date of separation is, and what they're asking the court to order on property, support, and custody. Note anything you disagree with. You don't have to resolve any of it immediately, but an accurate list of what's actually being requested is what your own response, whatever it ends up being, will be built on. Hold on to the original documents you were served, along with any note about how and when they were delivered. That date is worth writing down immediately, since your entire deadline calculation depends on it, and it should match the proof of service your spouse eventually files with the court. Speaking of that deadline, you generally have 30 calendar days from the date you were served, not the date printed on the petition and not the date your spouse filed, to file a response. Weekends and holidays count toward those 30 days. This isn't 30 business days, so it's worth marking it the same day you're served, before anything else gets in the way. With your deadline calendared and the petition read, you actually have real choices here, not just one path. Filing a response, Form FL-120, protects your position no matter what happens next. It puts your side of the facts and your own requests on the record, rather than leaving the case to move forward on only what your spouse asked for. Filing a response doesn't mean you're picking a fight, and it doesn't stop you from also negotiating directly with your spouse toward a full agreement afterward. The third option, letting the case proceed without a formal response, generally only makes sense if you and your spouse already agree on every term, or if you're exploring the newer joint petition process together from the start. Doing nothing simply because you're avoiding the paperwork is a different situation, and it tends to work against you. One important note here: if there's been domestic violence, or you're afraid of your spouse, get safety support first. Call 911 in an emergency or the National Domestic Violence Hotline at 1-800-799-7233. You can seek a domestic violence restraining order whether or not the divorce case is pending. Being served doesn't automatically mean you need an attorney, and plenty of respondents, especially in straightforward or cooperative situations, complete and file their own response. But a consultation is generally worth the cost if your case involves significant or complicated property, retirement accounts or pensions that need specific court orders to divide, a contested custody dispute, or if you genuinely don't understand what's being requested. If you do decide to respond yourself, the process is direct. Complete Form FL-120, stating what you agree with and what you want differently. Add Form FL-105 if you have minor children together. Pay the filing fee or request a fee waiver on Form FW001 if that applies to you, and file with the same superior court listed on the summons. Then have an adult who isn't a party to the case serve a copy on your spouse. The days right after being served are exactly when a clear next step matters most, and that's the specific problem Virdix is built to help with. Virdix offers a guided response flow built around your 30-day deadline that turns FL-120 into plain language questions and helps prepare your paperwork for filing. Virdix is a document preparation service, not a law firm, so this is not legal advice. And for advice about your specific situation, talk to a licensed attorney. You can find it at virdix.co.